Hello, and welcome to another edition of Right to Travel Debunked. Today's episode comes courtesy of Samu Mears, wrote, quote, citing the case Williams v. Fears from 1900, quoting, "Undoubtedly, the right of locomotion, the right to remove from one place to another, according to inclination, is an attribute of personal liberty, and the right ordinarily of free transit from and through territory of any state is a right secured by the 14th Amendment and by other provisions of the Constitution." Let's look into that. First of all, credit to Mr. Mears, who is actually quoting a real Supreme Court case. This is usually a good sign. However, the problems begin right in the first paragraph. As it explains, this is a Supreme Court decision dealing with a tax warrant. This is a tax case from Georgia involving a tax that was passed in 1898. Let's move on. Now, it turns out the quote he's reading and quoting from is actually a real quote. Again, another good sign, but I'm guessing you can already see where this is going. In a subsequent paragraph, the Supreme Court explains what it means by the right of locomotion. Quote, "This act is a taxing act, by the second section of which taxes are levied on occupations, including, by paragraph 10, the occupation of," this is a key part, "hiring persons to labor elsewhere, if it can be said to affect the freedom of egress from the state or the freedom of contract, it is only incidentally and remotely. The individual laborer is free to come and go at pleasure and to make such contracts as he chooses, while those whose business is to induce persons to enter into labor contracts, blah, blah, though left free to contract, are subject to taxation in respect to their businesses as other citizens are." So, despite what Mr. Mears is implying in quoting this case is not about whether or not you can drive your car from one state to another from point A to B. This case is about whether or not the state of Georgia or all other states can impose a tax on people hired from one state that are going to work in Georgia. And if you actually read the case, what the Supreme Court said was that no, it did not violate the 14th Amendment, and it allowed Georgia to tax people who were hired from one state and coming to Georgia to work. In any case, this is an excellent example of cherry-picking quotes out of old, 120-year-old Supreme Court cases to argue that you don't need a license to drive a car.